Both of them are again married.
Both of them got married again, but the second husband of mine refused to take care of the children. So I had to leave my lord and go back to my father and my brother. So my father and brother have been taking care of me and my children.
So why
Admitted,
are you seeking maintenance for this earning daughter?
not for earning daughter. It was
The other
still,
one.
it was still, no. It has been pending for a long time.
When was
There's no reference of any order. There's no direction to pay 3,000 rupees maintenance. We're not asking for profit, my lord, here. It is not a profit. You are a father, you must take care of the children. That's the least you can do. Educational expenses, food. Is this lady is not working? She does not have the ability to
It
work.
was a considered order, and the other party was also present. 3,000 each was given to the child. It was 13 years ago. At that time, that 3,000 was very good amount. Now, maintenance is not defined in any act, Family Court Act, Hindu Marriage Act, Maintenance Act, nothing. It is by the rule, by procedure, by precedents, by judgment laws. We have come to understand that maintenance is food, tuition fees, medical fees, their transportation.
criminal proceedings is not something about a maintenance.
No, it is not challenged. You are very much there for the past 10 years fighting the case in the court, and you did not challenge this 3,000. 3,000 was agreed.
And this is only for maintenance for the children.
Where is the order?
The father, my lord, has not paid any maintenance at all. May I? And my lord, this is an order where there's no consideration of any of the evidence at all. Please come to para
Both of
9.
them are again married.
Both of them got married again, but the second husband of mine refused to take care of the children. So I had to leave my lord and go back to my father and my brother. So my father and brother have been taking care of me and my children and have paid their school fees. Every single expense of theirs has been met by the father, and the father, my lord, is a retired person.
How much is the order?
3,000 rupees a month. I can only say, my lord, Lordship may kindly see the reasons given at para 20.
20?
20, para 20. It is an admitted fact that first daughter has completed her BE education and distinction, and now she's working. That's now. Petitioner taking contention. Now the first daughter is working and getting salary. There's no necessity to pay the maintenance amount.
So why
Admitted,
are you seeking maintenance for this earning daughter?
not for earning daughter. It was
The other
still.
one.
It was still no. It has been pending for a long time.
When was it filed?
Not the 2013,
And order came to be passed on?
24, 23, 11 December 23. And therefore, my
No
lord,
interim maintenance was granted in between.
and my lord, therefore, we have given all the records of all the payments made towards educational expenses.
So when this daughter has completed her BE?
B, my lord, when she turned, I think I'll just give you lordships that date. But the court, anyway, my lord, that may or may not arise because the manner in which the court has calculated the compensation is on some kind of an assumption that there is an order in the High Court saying you have to pay that much, and therefore that's all that has to be paid. And let me just quickly take your lordships. It's only 2-3 paragraphs where there's absolute non-consideration, I would say. Admittedly, maintenance amount is claimed by children prior to attaining the majority. When they were studying and required the amount, at that time they've claimed the maintenance amount. Without waiting for payment by the father, mother of the children, by taking assistance from her father and brother, completed the education of children. Now the petitioner cannot avoid his responsibility taking such a contention. Both children are studying at standard school, completed the education with hard work, and the result is also distinction. Admittedly, petitioner had paid interim maintenance of 3,000 each to the children as per order of Honorable High Court. There's no order of any court, my lord. According to petitioner, after deducting that amount comes to 1,89,000. He has calculated arrears which comes to 4,65,000 and has already paid 1,44,000 before the Honorable High Court. Arrears is only 3,21,000 and he is ready to pay the amount. It is a liability of petitioner to pay the school fee of the children. IN number 11. Respondent claimed 1,98,000 school fee of children which was taken by her from her father and brother. That was for 1 year.
Which order of the High Court they are referring to?
There is no order. I don't know which order it is. There is no reference of any order. There is no direction to pay 3,000 rupees maintenance. And nothing is placed before the court. And on that basis, my lord, for 1 year in IN number 11, we said you have to pay immediately the school fee, which he did not pay. That was 1,98,000. So the court says that is to be paid. But I have led evidence to show the entire calculation over the years of how much school fee has been paid. And there's no dispute on the amounts at all. Not a single dispute raised, my lord, with respect to the amount spent by us.
Marriage expenses at 8 lakhs each to the children.
8 lakhs to the children.
Uh,
1,98,000 is for 1 year school fee, 1 year's school fee. And 3,21,000 was arrears of maintenance. But the whole direction was that the court must consider what the maintenance amount is and make a determination. There's absolutely no consideration, and all the material law has been completely ignored.
We'll ask.
Very well.
Yes.
Your lordship may come to my writ petition 7838.
No, before you proceed,
Yes.
a high court, in which case has directed to pay 3,000, where is the order?
Order is dated 18/10/2016, my lord.
18/10/2000.
18/10/2016.
Is it filed?
It was it is not filed here. In another criminal case, it was ordered. In another criminal case, it was ordered.
You have a copy of it?
Today I don't have. I'll produce it. I have a copy. Today I don't have a copy.
The criminal case?
I thought they would not engage me on this or this court. I will produce this order of the court. It was a considered order and the other party was also present. 3,000 each was given to the child. It was 13 years ago. At that time, that 3,000 was very good amount. Now it may not be good amount, but I have paid up to the age of their attaining majority. I have paid up to date. 6,000 for 2 children. This is one aspect of the matter.
Then what about the school fees and other things?
School fees is, my lord, maintenance is not defined anywhere in any book. I have been making a research on this. Maintenance is not defined in any act, Family Court Act, Hindu Marriage Act, Maintenance Act, nothing. It is by the rule, by procedure, by precedents, by judgment laws. We have come to understand that maintenance is food, tuition fees, medical fees, their transportation. Therefore, the second order passed by the learned trial court judge asking me to pay school fees is a part of maintenance.
No, before that.
Therefore, my submission is there cannot be a maintenance for transportation, maintenance for food, maintenance for fees. That's my submission. My submission is 3,000 plus 3,000 for 2 children
No,
or
1 minute.
inclusive of all this.
In a criminal proceedings, that order is passed when? Which year?
18/10/2016.
18/10?
2016, 1/6.
This petition is filed?
This
No,
petition
that
is filed
not
in
that
13.
criminal proceedings is not something about a maintenance. No, when the petition is filed before the court, when the evidence is let in, court has to independently decide it, how much is the maintenance
Yes.
you're entitled.
Yes,
And after determining the maintenance,
yes, ma'am.
then this much of amount the father is already paying,
Yes,
deduct it, and then fix the maintenance.
yes.
But that is not done by the court.
No, my lord, it is not challenged. You are very much there for the past 10 years fighting the case in the court and you did not challenge this 3,000. 3,000 was agreed, was ordered and I paid 1,40,000 on that date I paid.
Unfortunately.
And there was no objection. You did not
Sorry.
file an application for modification.
No.
You did not file an application for 10 years.
Without an order copy being on record either before the court below
I'll produce.
or
for-
before this court.
Yes, ma'am.
Now we are talking about something of 6,000 and but unfortunately court below cannot say high court has asked in granted 6,000. So I will also do.
My lord,
This is an application.
it's not like that.
Application.
It's not like that. I'm sorry, my lord. It's not like that. It was adjudicated. It was consented. Parties were present. It's not an ex parte order. We were present. And from 16 onwards till today, 2024, you have not raised your little finger saying that it is more or less. You should have applied for a modification, applied for enhancement. That is not there. That is what is called as acquiescence. You have accepted and I have paid and you have accepted also. Therefore, you cannot now go back and say, this after 10 years in 2024,
Have you
when the
seen
girls
that
are, when the girls are drawing 1,50,000 salary. No, please sit down. I did not
Sit down, sir.
interrupt you.
I will take instructions from the
No,
court.
please
not
sit
from you.
down. Please sit down.
Tell me to
My
sit down.
lord, this you have raised when the 2 children have become majors 4 years ago, when the 2 children are earning 1,50,000 per month, and they don't have courtesy to tell me that they are doing this,
No, this IA.
Your
is
lordship
filed-
may kindly take.
IA is filed in 2013.
Yes, no, my lord, petition is filed. IA is filed in 16.
No.
From the date of filing the
When is
application.
IA filed for interim maintenance?
Interim, my lord, this maintenance has practically become the final maintenance today. Though it was initially an application, it has become final
No,
maintenance.
whenever it is.
Yes.
When is it filed?
My lord, the application was filed on 27/3/2013.
27/3/13.
2013
Yeah, right.
and 14/6/2013. That IA number 10 is filed on 27/3/2013. IA number 11 is filed on
Finally, the court has passed a final order in the petition
final-
itself.
in the
No, it's on IA.
1 minute.
IA 10 and IA 11.
Lord, I think I should explain this. Please see the page 111 of my petition. This order dated 18/10/2016 is here. This is the order.
Which page?
Page 111.
This is the one they're referring.
This is the order. Now, your lordship may kindly see this order.
18th October
2016.
2016. And this is
This is
arising out of?
in the GNWC case which they had filed for custody of the children.
Hmm.
We had filed an application for maintenance. Then, Lord, when the applications were being heard, they withdrew the petition. The question was, should these IAs be considered notwithstanding the so-called withdrawal? That was being considered. Your lordship may kindly see the order. That apart, it is no doubt true that the main petition is filed by the respondent herein seeking that the respondent be appointed as guardian of the minor children. That is my learned friend's clients. It is in such proceedings by invoking the inherent power of the court, an application is filed with the petitioner herein with whom the children are residing, seeking for appropriate orders for payment of school fee. In fact, that was one of the aspects which should have required consideration by the court below, since when the petition seeks appointment to the respondent as guardian of the minor children, whether the respondent is interested in taking care of the welfare of the children is also one of the aspects which should have weighed in the mind of the court below. And if such consideration was to be made, certainly the court below ought to have taken note of the contention and merits to come to a conclusion as to whether the respondent is capable of taking care of children. And in that light, whether the respondent is to be directed to either pay the maintenance or the school fee by taking into consideration merits of the contention and expenses as claimed by taking note as to whether such amount has been expended on the children and to what extent the respondent should be held responsible for maintaining children in the context. And that is how these IA 10 and 11 are directed to be considered. From that date till 2024, my lord, these applications have been pending. And now it is considered saying simply on a statement made that 3,000 rupees was paid by me and therefore that is the amount of maintenance and therefore nothing more has to be paid. You must not look at any of this voluminous evidence that we have placed before the court, pointing out as to what is the exact expense. We are not asking for profit, not here. It is not a profit. You are a father, you must take care of the children. That's the least you can do. Educational expenses, food. Is this lady is not working? She does not have the ability to work. Now she is at least ensured, Lord, with the help of a father and a brother, children have been given an education. Otherwise, the children would have been on the streets today. And today the father is saying, I'll pay 3,000 rupees, that is maintenance.